By using the word barbaric, are you, by extension, then calling the communities where some of these practices that we've been talking about here today have existed, are you in effect calling those communities within Canada barbarians?
Which communities do you mean, Senator Eggleton?
The communities that where some of this practice of marriage, forced marriage, or honor killing, all abhorrent as they are, they do exist in some communities, perhaps to a very small extent, but nevertheless, are you calling those people barbarians?
I think I was very clear just a few moments ago in saying that the community at which this bill is addressed is the community of those who perpetrate violence against women. It knows no bounds of culture, nationality, language. Some are immigrants, newcomers to Canada. Some are Canadians of long standing. We have a challenge of missing and murdered Aboriginal women in this country. We have a challenge of cyberbullying in this country.
Do something more about it, yes, that would be good. But are you calling people in these communities, aside from the people that perpetrate these specific acts, are you generally casting these communities as barbarians?
Well, you still haven't told me what community you're talking about. I'm talking about one
I
community.
just described it to you a few minutes ago, and I think you know.
No, your description actually lacked any content.
No, I'm afraid I'm asking the questions and you're giving the answers, I think is the way this goes.
I haven't asked you a single question. I gave you the answer.
I've asked you the question.
Yeah, and then you interrupted my answer.
No, I'm saying, are you calling communities barbarians?
I am calling those who commit violence against women guilty of barbaric practices. Hence, we have this bill. Are you trying to tell me that this practice is not barbaric?
No, I'm asking the questions. The forced marriages, honor killings, polygamy are already against the law. Why do you? They're already part of the criminal law of this country, covered by things like abduction, forcible confinement, homicide, abuse, etc. Why is this necessary?
Because they're still happening in Canada.
Yes, well, then why don't you prosecute them under existing laws?
Because the existing law is sometimes not sufficient to allow for the prosecution. And if we had not taken strong measures across the board over the past 8 years, we would not have a crime rate and a murder rate that are dropping as quickly as they are in Canada. I regret to say that the murder rate, for example, in this country rose astronomically in the 1960s and has only gradually started to settle. It was still quite high in 2005. Over the past 8 years, it has fallen dramatically thanks to a variety of measures taken by this government and cooperation of law enforcement, prosecutors, justice professionals across the board to bring perpetrators of violence to justice and to ensure that repeat offenders are not released too soon back into their communities to reoffend.
Yeah, but you've been in government now for, what, 8 or 9 years, and you still haven't got a conviction on anybody of polygamy? And yet it exists within this country today?
We're very proud to say that we've had arrests and charges laid for polygamy for the first time in over 100 years in this country, and it never happened under a Liberal government, not once.
On the question of provocation, can you give any examples where the courts have allowed testimony about honor killing as part of a provocation? Do you know of any cases where I think we all find that equally abhorrent, but do you know of any cases in the courts where
Yes.
that's happened?
Yes, I do know.
Where it's been successful.
I know of at least one case where it was successful and dozens of cases where it was brought by the defense.
Can you name the case?
I can. I can also defer to my colleagues from the Justice Department who have detailed knowledge, but I'll name the case for you. Stone, 1999, 2 SCR 29. This is not an honor killing, but a killing where the defense of provocation was used. And that's essentially.
What's that case?
It is Stone, 1999.
But it was not an honor killing case.
It is a killing where the Supreme Court found that the legislative objective of the provocation defense was to reduce murder to manslaughter, so that the mitigating nature of provocation be taken into account on sentencing. There was use of the provocation defense and successful use by the defense.
I think the issue here is, in terms of your bill, is S7 is on the basis of an honor killing having been used successfully, and there is no case.
My response to your claim, Senator Eggleton, would be to say that the defense of honor as a basis for provocation has been used in dozens of times in Canada. And its very existence under our criminal law weakens the defense that women and girls deserve to have in their own homes from their own relatives. We should not be allowing there to be any concept of family honor, however construed, as a mitigating factor for the murder of a family member.
And we never have allowed it.
But I find it astonishing.
The court has never accepted it.
I find it astonishing that a member of Canada's upper house would be questioning whether the weakening for the protection of women of a defense by reference to honor was justified. It could be used in the future, and its very existence sends a message to men and family members across the board in homes across this country that their honor is somehow at stake and could be used to defend them in a court of law from the charge of murder.